Hi everyone, it's John Boy here, and today's webinar is in relation to assets overseas and going through a divorce. So the webinar relates to when parties are separating and they hold assets in different countries and different jurisdictions. And so a lot of questions arise out of this. So we thought we'd put a webinar together to see, to try to educate and explain a little bit about what solicitors do in this situation and how the courts determine how we divvy up these assets. So the first thing is just a bit of housekeeping. I'm not sure if this is the first time that you've used webinar or the first time that you've listened in to one of our webinars, but you'll see this little box and there's this orange button here. This box you can minimize and maximize right here, so it's easier for you to see the slides. There's also a question box down here as well. If you have any questions, don't hesitate, just type the question in there. I'll try my best throughout the webinar to answer the questions in the question box, but if I don't get the chance to, then I will attend to you at the end of this webinar. Perhaps we could chat, or I can answer your questions via email, whatever works better, but I'll endeavour to answer as we go. There's also another box here. It's the raise your hand box. Can I just get everybody in this webinar to raise their hand so that I know that technology is working well and that you can all hear me. If you can't hear me, then please let me know by putting by typing it in the question box. If you can hear me and we're ready to proceed, click this button here and we can get started. Okay, good. Looks like everybody technology is working well and everybody can hear me clearly. Just a disclaimer, this is just a webinar to provide general information. It doesn't constitute legal advice. Every case is different. There's always different facts, and any advice that we need to give needs to be tailored particularly to your facts. It's just to give you an overview so you can kind of understand a little bit about the process and about what's entailed. Perhaps you can start thinking about some of the information that you want to provide to us and some of the facts in your circumstances that would be prudent in this case. Okay, not only just the webinar, but our newsletters, our articles, is all general advice. Please do not consider it as legal advice, and just because you are listening to this webinar does not mean you become a client of our practice. Okay? All right, assets outside of Australia. So it's starting to creep up a lot that people have assets in different countries. It's quite often that people migrate to Australia and have assets in another country like the United Kingdom, or perhaps in America, or some countries in Southeast Asia, a lot of people from China, and they meet somebody here and start generating some assets here, which creates this situation where there are assets in a couple of different countries. So it's creeping up a lot more. Australia is obviously a relatively young country, and these sort of situations are definitely being brought to the court much more consistently. So what's an asset? Real property, of course, land, houses, units, bank accounts. You might have a bank account in another country, and in Australia, that bank account might hold significant amounts of money. There's also superannuation that we have to consider. Inheritances. A lot of people migrate to different countries from the country that they were born, and their parents or an aunt or an uncle might pass away and leave an inheritance in that country. What does that mean at the time of separation? So that's what an asset is. So do you have to disclose your assets? Yes, you definitely do. In Australia, there's a requirement for full and frank disclosure disclosure of your assets, liabilities, and your superannuation of the documents that you have in your possession and or control. Well, it doesn't matter if they're in Australia or in another country. So you can't say, okay, this asset I had prior to my relationship with my partner, and it's in another country. I don't have to. I'm not going to disclose it. You can't say that. In Australian courts, in the family court, we believe in full and frank disclosure. It's a rule, and we must comply with that rule. There are definitely a couple of reasons why you should disclose. One of the reasons is that if you don't disclose and we find out about it, the court might invalidate the orders that were previously made. So let's just say you and your partner are in the midst of a separation. You provide a list of your assets in Australia, but you leave out the assets in another country, and then orders are made, agreements reached. Okay, we're going to divide. You keep one house, I keep another house, etc. If it's later found out that there are assets overseas which you didn't disclose at that time, those orders are likely to be invalidated because the court is unable to make a just and equitable order determining having in consideration everybody's assets from all different jurisdictions and all different countries. What that might mean is it can be quite costly for you, because if an application is brought by your partner for you not disclosing an asset, it's likely that the court will make a cost order in that case, and you'd have to pay not only your legal fees, but the other side's legal fees, a proportion of the other side's legal fees. Okay? So disclosing the assets, as I said, allows a just and equitable order to be made. Otherwise, we can't make a fair agreement when we don't know everything there. It allows the court to make an order adjusting the property interest of the parties as between them without controlling or exercising jurisdiction over the foreign asset. Yeah? I'll go into a little bit more detail about that in some later slides, but basically, enforcing an order for the division of an asset in a foreign country holds a lot of difficulties. So what we tend to do is direct the person in Australia to do that, and that's how we exercise our power. But let's talk a little bit more about jurisdiction and power in the next couple of slides. Okay, so what's jurisdiction? Jurisdiction means that is the court capable of making this decision? Is the Australian courts capable of making the decision? Is the exterior court in another country, do they have the jurisdiction? All right. So simply put, if we determine through our test that Australia has jurisdiction and the other country doesn't because of their laws, then obviously Australia will be the court with the jurisdiction. Australia will be the court that will determine the property dispute. But it obviously gets a lot more complicated than that. So what the Australian courts do is we use the closest connection test. And we say that whichever country has the closest connection to the parties will have jurisdiction over their family law proceedings. Okay? The closest connection test considers the following factors. Where do the parties usually live? Where are most of the parties' assets? So the combination of those two questions. Now, you often see that parties dispute this because, for example, one party might want the jurisdiction to be Australia because the Australian laws provide them with a better outcome, whereas the other party might say, well, I prefer the laws in the United Kingdom, so I'm going to make an argument that we have a closer connection to the United Kingdom. Okay, so that's where you often see two parties competing in separate courts because they want a certain court to have the better jurisdiction. The certain court to have the jurisdiction because it provides for a better outcome pursuant to the law in that country. Yeah. So jurisdiction is one question. So once the application is brought and the court makes a determination as to the closest connection test, the court then has another obstacle to overcome, and that's whether or not the parties, the court, the non-jurisdiction country will recognise and enforce the orders made in the country with jurisdiction. So it's all good if Australia says, okay, the closest connection is here, but the assets are, there's a significant asset in China, and we need to sell that asset and divvy up the assets. it's all good for Australia to say that. But if that order was if a court in China took that order, will they enforce it is the question. And that's something that we have to consider. If the country is not going to enforce that order, then we might have to consider a different approach. Yeah. So there are heaps of different scenarios, heaps of different facts. And the case law on this is very, very interesting. Some of the cases we've been involved in have always been very interesting. But at the end of the day, it all boils down to looking at the different considerations and basically making a decision which is in the best interest of everybody involved. Courts attempt to be fair and reasonable, and if once we looked at all of the circumstances and the facts of the case, the Australian courts will try their best to make a decision that benefits all parties as best as we can. So there are heaps of factors, and this is not exhaustive list. This is just a couple of things that we've picked up over time. Your case obviously might be quite different to this. So if there's something that you think is of significance, obviously bring that to the attention of your solicitor, and it might be a point that needs to be argued in court to determine which jurisdiction we go to. So here are a couple. As I've indicated, whether both courts have jurisdiction to hear the party's case. I assume if one party doesn't have jurisdiction, then obviously it's a pretty easy question as to which jurisdiction we use. If both courts do have jurisdiction, which will each jurisdiction recognise the other's orders and decrees? Will they recognise our order? Will we recognise theirs? Which jurisdiction may be able to provide resolution to all of the matters involved? Okay, so Australia has a very strong focus, and the United Kingdom's a little bit different, but Australia has a very strong focus to finalise the entirety of the dispute between the parties to bring an end to the proceedings. And the reason for that is we want animosity to die down. We don't want two parties that perhaps or maybe can't stand each other to be intricately woven with their financial circumstances. So we tend to favour a situation where the court can just bring a complete stop to the litigation and the dispute, because it's stressful, it's tiring, there's a lot of cost involved in it, and nobody wants to be in lengthy litigation. We want to get out of it as quickly as we can, so parties can move on with their lives. The time when each of the proceedings were commenced. So obviously time is an issue if proceedings have been commenced for a couple of years in one jurisdiction and then another party attempts to bring proceedings in a different jurisdiction to attempt to change the outcome, then that's going to play a strong weight on the Australian courts here. The stage at which proceedings each of the jurisdictions had reached, the cost that parties have incurred, that's also a significant factor. At the end of the day, we want to make sure that the money that you have accumulated, the wealth you've accumulated over time, you preserve as much of it as possible. And obviously, the decisions made by the court will attempt to minimise the cost for all parties. The connection between the parties in each of the respective jurisdictions, I'll go into a bit of detail about that, whether both parties were able to participate in each of the jurisdictions on equal footing. So, for example, language barriers in connection to that country. Taking into consideration the issues that are particular to that case and the general circumstances of the case. So I'll put an overarching clause in there to talk about all issues and considerations that the parties will come to. Okay, so commence proceedings in overseas jurisdictions. So you've decided that, okay, the best course of action is for me to commence proceedings in an overseas jurisdiction. Here's a number of things that you should consider. Did you enter into a prenuptial agreement, a binding financial agreement, or a postnuptial agreement? Is that agreement going to be recognised in that jurisdiction? So think about that before you pull the trigger and decide to commence in a different jurisdiction. Are the assets overseas? Is there property over there, super pension entitlements? Obviously, if you're thinking about commencing proceedings overseas, that's probably one of the biggest factors that you've considered. Tax implications. Tax laws change and vary all the time. And they can be quite different in Australia and in another country. Think about the order that you want. get advice about the likelihood of you getting that order, but not only from a solicitor, but then from a tax, from your accountant, because different countries have different laws, and the separation of assets can trigger tax events. Child support. How is child support considered in different countries? How does it work in Australia? How does it work overseas? Overseas spousal maintenance orders. How does it work overseas? How does it work in Australia? Is it enforceable, right? Particularly in Australia, we try to have a minimum period of spousal maintenance, but in countries like the United Kingdom, and I bring up the United Kingdom a lot because there's a lot of cases where there's assets in the United Kingdom and in Australia that have come before the courts. In the United Kingdom, they've got a long-term spousal maintenance orders are not uncommon. So have a think about that as well. Distribution of assets. How will this occur in the foreign jurisdiction? Protective orders is important. Does the foreign jurisdiction have powers to grant orders to stop your ex from dissipating assets? You should consider that, and you should definitely consider that as soon as proceedings are commenced. Should you apply for a protective order as soon as possible, right? If it's required that you need to file protective orders overseas, definitely speak with us, and we can put you in touch with the right people and assist in preparing the documents for protective orders in different countries. Okay, so value of the assets is very important. Depending on the significance of the asset, there may be issues with coming to an agreement on how much that asset is worth. So if there's an asset in another country, we obviously have to have a discussion about what that asset is worth. And then if we can't reach an agreement, then perhaps we have to appoint an expert valuer from that country to determine that valuation. I have previously sought for a valuation of an asset in an ulterior country, but the expert was Australian based. Sometimes that's quite possible. So definitely speak with us so we can put you in touch with the right people to see how we determine the value of this asset. Okay, so how can we help? JB Solicitors provides a first free consultation with one of our solicitors. Give us a buzz. Consultation can occur either on the phone or in person. And hopefully at that consultation, we'll be able to map out your family law proceedings, what your likely outcome would be, how much it's likely going to cost you, and what your first step should be in all of this. We've implemented robot advice. Technology is very important to stay up to provide legal services at a cost-efficient and speedy way to our end consumers, to our end clientele. So if you're not ready to give us a call, or if you want advice, written advice, just jump online, follow that link, and you will be able to fill out a form. After that, we'll shoot you out some information. It will start teaching you a little bit about how we separate assets, or how we consider separating assets, or how we consider parenting plans as well. The problem that we often have is that we do this on a daily basis, it's become second nature, but we always have to remind ourselves that this is probably the first time that you've done this. So get as much information as you can. Listen to these webinars. We run them on a fortnightly basis. Jump online, fill out Certify. It's very, very useful. We have a bundle of articles. Sign up to our monthly newsletter because there's heaps of information that we try to get out there into the community. One of our main objectives, obviously, is to educate you as much as we can. The better that we can educate you, the better you can understand what the process is about and alleviate your stress and your anxieties, which in a time, obviously, where you're probably quite stressed about what's happening in your life. So yeah, get out there, educate, learn more. Call us. We're approachable, we're friendly. 1300 287 911, or call me on my direct line after this webinar, 029723 8080. I get quite excited when people want to find out a bit more information. So yeah, I hope that this webinar was useful to you. Thank you for tuning in and listening. Thank you for allowing me 25 minutes of your time. I really appreciate it. And yeah, I'm going to end the webinar now. Reach out, ask me any questions, let me know. if I can be of any further assistance. Until next time, bye.